are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host. You know, I wish I was on the Senate Banking Committee, and I wish I was asking questions of Gary Gensler, because I can assure you they'd be a little bit different than what's happening. Same old, same old. Unfortunately, it seems like, what we have the old Democrats are going anti-crypto. We're talking about Sherrod Brown, who's the chairman of the banking committee, Brad Sherman, who's on the financial services committee, Maxine Waters on the financial service committee, Elizabeth Warren. You got the old Democrats who are going anti-crypto, and you've got the Republicans who are adopting crypto, whether it's sincere or not, I don't know. And then you've got a contingency of younger Democrats, the Representative Richies of the world. And so we do have this generational thing taking place. I'm really not paying that much attention. The Senate Banking Committee is run by the Democrats, and obviously the single most powerful person on that committee is Elizabeth Warren. And we know that she's buddy-buddy with Gary Gensler. She shares her questions with him and makes sure he approves, and they get together and conspire to gaslight the American people. And so as long as she's got the influence she does, I'm really not going to pay much attention. Go to Eleanor Terrett. I know she's tweeting things related to it, but I'm at the point now where I'm frustrated, and I know you are, because enough of the damn letters, man. It is time to issue subpoenas, congressional subpoenas, where they do not get complied with. You get a court order, you send the marshal down there to start bringing people in before the committee. It's rarely done. I don't know why. It's why I hate Democrats and Republicans together equally, because they seem to almost have this unwritten rule. Well, we won't go that far. We'll write letters and we'll pontificate and we'll engage in rhetoric, but we're not going to actually institute some type of change. It is time for that. Gary Gensler is a cancer on the American economy. He is a cancer on innovation. And it's not just him, but he's the head of the SEC. They're leading the fight. It is time to get him out of there by putting pressure and real oversight. Today's topic is this Coinbase motion to dismiss that I want to talk to you about, because I may be getting my hopes up a little too high, to be honest with you. I'm trying not to. I'm trying to stay grounded. And before I said that this Coinbase motion to dismiss, that it had like a 25 or 30% chance. I said that a few weeks ago. That was before Judge Felia, the same judge on the Coinbase, came out with her Uniswap ruling. And just like Judge Torres, man, she gets it. And just like Judge Torres, when you read that opinion in the Uniswap case, I mean, she understands the technology. She understands the concept of decentralization. And after that decision, I was like, oh, wait a minute, this 25, 30%, it could be getting up there in that 50% range. And so we're going to talk about that, because that could be the biggest ruling. It would be the third nail in the proverbial SEC coffin as it relates to regulating crypto. And I'll explain to you why. But here's the three things we're going to talk about real quick, right? Which is, what is this motion to dismiss that I'm talking about, that I'm getting my hopes up maybe? And what is the basis for it, basically? What's Coinbase's argument? And then finally, what's the SEC's response? And then we'll talk about some of my thoughts. Okay, so basically, the motion to dismiss that the SEC filed. The SEC filed a case against Coinbase, saying that they are an unregistered broker dealer clearinghouse, that they are engaging in securities, and they are not registered with the SEC to sell securities. So they are therefore an unlawful business. They are operating illegally in the United States. That's in essence what the SEC is arguing. Remember, the SEC is a civil, law enforcement type agency, not criminal. So when they say it's illegal, they don't necessarily mean, we're not talking about illegal as in go to jail illegal. It means you're breaking U.S. securities laws. And in this lawsuit by the SEC, they named 13 tokens and they say those are unregistered securities. And they algo or whatever. And then, of course, there's a staking element to Coinbase. They offer staking, and they said that was also an unregistered security. Now, we have to back up for a second and just conceptually think, because Judge Failure, right, she brought up these very issues at the first hearing. And remember, Judge Failure is in the same courthouse as Judge Torres. Now, she basically pointed out, which was, wait a minute, in April of 2021, the SEC approved the registration statement and the S1 of Coinbase. And I had Paul Gruwell on, who is the chief legal officer of Coinbase on crypto law, and he explained to us that Coinbase asked for acceleration. And acceleration, in order to be granted acceleration, the SEC has to make a finding that it is in the public's good interest. It's basically in the public's interest for Coinbase to be granted an acceleration for their IPO. And that determination was made by the SEC. And then you fast forward. Now, remember when Gary, and this is relevant for this motion to dismiss, when Gary Gensler testified at his confirmation hearing, at that moment in time, he admitted that the crypto fell in this regulatory gap. Basically, exactly what was admitted in the Hinman emails by the SEC's general counsel, that there's this regulatory gap where crypto, is really not a security. These are assets, they're software, digital code. Are they securities? Are they commodities? Are they just cryptocurrencies? What are they? We really don't have regulatory oversight over them at the SEC, and neither does the CFTC. So it's this gray area, if you will. That's basically what he said. But again, in 2021, the SEC approved the IPO. And so the judge just said, well, this makes no sense. Why would you let them basically go public, make this finding that it's in the public's interest for acceleration of the IPO, and then 2 years later say the entire business model is illegal? That just makes no sense. And so this is what Coinbase basically responded in their motion. This is what they're saying to the judge. They're saying, look, judge, these are not securities. There's no way that Howey test applies in the secondary market to these assets that are sold on an exchange between a seller and a buyer who don't know who each other is. That is not what Howey and the Securities Act envisioned with investment contract, basically. And that fits very nicely with the fellow Judge Torres, where she talked about the programmatic sales on exchanges, where how do you rely on the efforts of the person you're buying it from if you don't know you're buying it from them? And you don't, and you can't rely on those efforts. There's no promises between the buyer and the seller on that at that moment. And so that's one issue that the SEC said, look, Howey and the securities laws doesn't even apply. It's an asset transaction. Now, remember what we XRP holders made a huge deal about in our amicus brief to the judge, the Ripple case, Judge Torres. We pointed out that in 80 years of U.S. securities laws, there's not a single case that the SEC can cite where the second sale of an investment contract was also held to be an investment contract just because of the original sale. And the only case that involves a secondary sale of an original investment contract is a case where it involved a condo. And the court actually found that Howie didn't apply to that secondary sale. So it'd just be like the Howie person who buys the orange grove and then they die. And then their estate sells that land grove to someone, at an estate sale or an auction of the estate assets. You don't even know the Howie is. You just buy some acres of orange groves. That's not an investment contract. That's not a security. And basically, that's what the SEC is saying. Of course, they raised the major questions doctrine. And the major questions doctrine, a lot of you have heard that recently, is basically unless Congress has specifically authorized the federal agency to do exactly what they're trying to do, unless it has specifically been deferred and outlined for that agency, and it involves something of economic significance in this country, then you can't do it, right? You can't do it. Congress must do their job. Congress must create some law that then authorizes that agency to do that specific thing. And so the one big issue that Judge Rakoff was wrong about in his decision, he said that crypto, it's really not, I'm not going to say it's meaningless, he said, but it's not, doesn't rise to great economic significance like tobacco did or the energy in this country like oil does. And I would say to Judge Rakoff, sir, do you know that cross-border payments alone, the single thing that Ripple was focused on, that XRP was great at or is great at, that one category is $157 trillion a year gets processed in cross-border payments. So I'm pretty sure that that's economically significant. All right, 157 trillion. Now think about the foreign exchange difference in bridging assets on a daily basis. I mean, think about all the other use cases economically, the banking industry and elsewhere. It's incredible, right? We're talking about hundreds of trillions of dollars. And so crypto does have rise to that level of economic significance, and major questions would apply, in my opinion, if we get to the Supreme Court. So, and Gensler admitted it. Now, that's basically what the major questions doctrine is. Obviously, Coinbase brings up due process, fair notice, all of those things. They have briefs and exhibits. They cite the Ripple case. They cite Torres decision, which is very favorable, of course. And, the question is Judge Failure going to be inconsistent? Or is she going to sort of adopt the same rationale that Judge Torres did? Some argue, well, is she going to do what Judge Rakoff did? I believe, and I'm willing to go out on a limb to say it, I believe very much so she's going to align up with Judge Torres and Judge Torres's way of viewing it. Okay, let's see what else we got. Now, of course, what's the SEC's response? The SEC's response is basically to blame. They basically say, look what Coinbase does in their registration statement that of course the SEC approved. Now get this, the SEC has to approve the registration statement of Coinbase. Coinbase, in order to get it approved by the SEC, needs to include language like, hey, one of our risks is that the SEC one day could say we're selling an unregistered security. They have to submit that kind of stuff in order to get approval. And then what's the SEC do now? They're like, look what they said in their registration agreement. They said to their shareholders, hey, one of the risks is that the SEC could come along and say that we're engaging in the sale of unregistered securities. So basically, you talk about circular reasoning and piggybacking and bootstrapping something. But they basically say that, and they say, look, Coinbase has to warn their shareholders every quarter of their risks. One of the things they say in their statement every quarter when they disclose risks to their business, well, if Satoshi Nakamoto comes out of hiding, or he's identified, or she or they, and it becomes aware and starts selling Bitcoin coins, that could risk our business. That could risk our platform. Another thing, well, because it's so vague, because the SEC won't give rules, we have to throw in there, we got to cover our butts and say another risk, of course, is one day someone could say we're selling unregistered securities. And so that's the argument by the SEC. And I want to play something that Paul Graywell not testified, but spoke to an interview, because he really sums it up, and then we're almost done for the day. Let's check this out.
This is not just about Coinbase, its leaders, our shareholders. This is about all of us in the industry. And that's one of the reasons why I've been so inspired by Brian Armstrong and our board in committing whatever the resources necessary to put on the absolute best case we can, because so many people all over the world are counting on us to do our very best. Now, you asked about winning and losing. One of the things I think that often gets confused about how Coinbase is thinking about this case is that we somehow have to win it all or else we lose. And certainly the SEC, or at least the chair, has suggested that, if we just prove one token in one case was a security, it's game over. That's just not true. The reason it's not true is that, our objective all along, our definition of winning has been, give us clarity on what the standards are. Tell us what the rules are, and we'll comply with them. I happen to think we're going to win this case, and I happen to think we're going to win across the board. But if I'm wrong about that, if we lose on a token or product or service here or there, if the court does what I expect it will do, and we should all expect it to do, in laying out the standards and rules that underlie that decision, we'll comply, and others will be able to comply in a way that just isn't possible today. So that's why we have been so insistent.
If you enjoyed this clip, watch the full episode now on Unchained.
All right, I want to make sure that great clip that Crypto Law gives credit to the Unchained podcast. Laura does a great job, gets some spectacular guests on there. So I encourage you to check out her channel. So what and who, let me ask it that way. Who did Paul sound like a few years ago? You could just substitute Brad Garlinghouse, and almost word for word, we're begging for clarity. We just want to know what the rules of the game are. We just need to know so that we can adapt and we can comply. Even if we disagree with what you say or what you come down with as a rule, just tell us what it is so that we can comply and move forward with innovation in this country. Sounds just like Mr. Garlinghouse. And here we are. And so here's the thing I want to talk about. Why the SEC does it, right? They want it vague. We know that because entrepreneurs will comply. So basically what the chief legal officer of Coinbase was saying is, okay, we don't think they're the tokens or any securities, but if a judge or someone says this token is unregistered security because of these reasons, okay, we'll remove it. And, we'll learn from that and we'll adapt and overcome and move on. And that's basically what he's saying. Now, he also sounded like Brad Garlinghouse when he said all those things, but he said, I think we're going to win. Brad Garlinghouse said the same thing, and there was a huge victory that's going to be celebrated sometime this month. And so I misspoke earlier. I want to make sure I know that because I tweeted out there were like 3,000 Coinbase customers in Amicus. It's about almost 4,500 who have joined. And so if the motion to dismiss, what I'm going to sum up here in a second, doesn't win and it's not successful, or there's a partial win and partial loss, and there's a need for customers to be heard, we will go into the Southern District of New York, just like we did in Ripple. We will file amicus request and amicus briefs and make sure that not only does the SEC not speak for us, but Coinbase doesn't speak for us either. And that's very important. So right now we have if this motion to dismiss, I want you to understand, and that's how we're going to end the show today, how big of a victory it is. It's game over. And I'll tell you why. We've got two major victories so far. We've got the Ripple victory that we helped become a victory. We all know that. And we've got the Grayscale victory. I'm proud to say that I predicted both of those victories before they came out. And now those victories are huge. Well, this Coinbase victory would be the third major win, the third nail in the coffin. And it basically would say, if, let's just think about what could happen. If the judge says, just like Judge Torres, she says, these are assets. Coinbase is an intermediary, and these are simply stripped down. XRP is not a security. Algo itself isn't a security, et cetera, et cetera. And you're in a blind bid ask transaction where the buyer and the seller do not know each other. And at the time of that purchase, all obligations are over and extinguished. It's a one-time transaction. You buy this token, you're not entitled to anything from the buyer. You're not entitled from anything from Coinbase as the intermediary. That's all it is. And therefore, you don't have a right into some type of business or enterprise. It is not an investment contract. Howey does not apply to this type of transaction. If that happens, then the SEC would lose. The motion to dismiss would be granted. It's possible that there is a split victory, meaning, remember, Coinbase has a staking program. So it's possible, and it's getting closer and closer where it could be where the judge says the staking component, I'm not saying she will, but the staking component is trickier because there's more of a direct relationship between Coinbase maybe and this person. There's reliance on others for profit. You know, it gets a little bit grayer, to be candid and objective. But these tokens themselves, they're just not investment kind of huge for the industry, because what does the SEC do? Well, a lot of you out there are going to say, well, you appeal it. The SEC is just going to appeal it. No, not so fast. The SEC doesn't automatically be the one who decides who appeals it, whether to appeal. They request it. It goes to the Solicitor General of the United States of America, who then decides, is this something we want to appeal? And here's the danger. If they say, yes, we want to appeal a motion to dismiss loss, Judge Failure grants it for Coinbase, then it goes up to the next court. It could reach the Supreme Court fast. And if the Supreme Court then agrees with Coinbase and clearly adopts the major questions doctrine, and then starts talking about how the administrative state is out of control, and how these federal agencies are out of control, and how these federal agencies all must be given specific regulatory guidance or powers and authorities by Congress itself, then we're talking about the FDA, the EPA, the CFTC, the SEC. It just goes on and on and on. And it would be a massive reduction of administrative powers of the executive branch for these agencies. That could be game over for certain policies that want to be implemented by the Biden administration, or even it could be a Republican administration. Is the Solicitor General going to risk not just losing crypto, but much more powers across all other federal agencies because the highest court in the land came down and set a ruling? I don't think so. I do not believe the Solicitor General is going to say, I want to die on that crypto hill for the SEC, for Gary Gensler. I don't see that happening. So if this motion to dismiss is won, I think it's game over. And I think at that point, because the Solicitor General wouldn't grant approval, Gensler has to pivot. He has to, because there's no other option. All right. And I think that would probably be the short he'd probably be on his way out, because the administration would know that they need someone new, someone fresh to come in and to execute that pivot, from anti-crypto to, okay, what can we do to protect consumers and foster innovation? Okay, so that's really my thoughts. Some of you may not see it, but I have this little necklace on with these brass knuckles. In about a week, I'm going to announce something very, very significant for me. I'm very excited about it. I'm looking forward to it. And with that said, see you next week.